Well, this week, a three-judge panel from the Federal Appeals Court in Washington, D.C. unanimously decided that the Federal Communications Commission does not have the authority to regulate high-speed internet. On this edition of the Communicators, we'll talk with several parties involved in the net neutrality debate and potential implications of the court's decision. We'll start first with Representative Joe Barton, a Republican from Texas, and the ranking member of the House Energy and Commerce Committee, which holds jurisdiction over telecommunications matters. First of all, Representative Barton, were you surprised by this decision?
No, I was not surprised. I'm very pleased by it, but I think the court did exactly what the law says, and that the FCC does not have the authority under current law to regulate the Internet.
So does that move the issue of net neutrality back to Congress?
Well, if it needs to be moved, I would hope that Chairman Waxman and Subcommittee Chairman Boucher and former Subcommittee Chairman Markey in the House would let a sleeping dog lie and not go forward. The court ruling was 3-0. Experts in the law more knowledgeable than I have indicated that they don't believe that it can be overturned on appeal to the Supreme Court, and I am absolutely certain that if they do try to do something legislatively, there'll be a lot of conservatives like myself that would fight a legal change in the law.
Well, two questions. Number one, your colleague, Representative Ed Markey, has already said that the appeals panel should not be the last word when it comes to net neutrality or net management.
Well, of course, because it didn't go his way. If it had gone his way, he'd have said he'd been fine with it. But since this particular appeals court ruled what the law really is, he's not happy about that.
Well, can Congress give the FCC power to regulate high-speed internet?
Yeah, if we want to change the law, we can. You can't interpret your way to it. I mean, the court ruling is unequivocal in that regard, but we could certainly change the law and give them explicit authority, which is apparently what Mr. Markey wants to do.
So when do you expect some movement on this issue in your committee?
I will work to make sure there is no movement on it. I don't think we need to legislate. I think the Internet is booming. I think telecommunication policy in America today, which is based on free markets and private capital, has been very, very successful. It's one of the few areas of the economy that is expanding and is profitable. If it's not broke, don't fix it. So if they choose to move something, we'll participate in the hearings, and we'll try to make sure that the free market witnesses have equal access to the committee. And I would predict that we will be able to defeat any bill that they tried to move to regulate the Internet.
In your view, Mr. Barton, what are some of the implications if Congress does pass a bill saying that the FCC can regulate broadband?
Well, you'd have less innovation on the Internet. You'd have less freedom on the Internet. You'd have over time a more restrictive Internet, probably a higher cost Internet. You would slow down the broadband deployment. The private sector has spent billions and billions of dollars in the last decade putting in the infrastructure, and it's almost now ubiquitous that everybody in America not only has a PC where they, at their home and at their work, but they also have a handheld device, a BlackBerry or an iPhone, that has access to the Internet. We're in the middle of a big success story. And keep in mind, all the court ruled was, Comcast said it reserved the right to charge people that used a lot of their broadband capacity for high-definition video and stuff, that Comcast reserved the right to charge them a little bit more, and perhaps on occasion to manage access at high peak times. Now, Comcast actually never did it. They just reserved the right to do it, and the FCC said that Comcast did not have that right, and that the FCC said that we the federal government, can set the terms and conditions that for people that are providing the backbone of the internet, the actual infrastructure. The court ruled that the FCC didn't have that authority, and that the Comcast of the world, who make the investment, can make sound business management decisions. People who use more and use it more frequently might have to pay a little bit more, but Comcast nor any other provider has ever tried to restrict access in the sense that little guys don't have the same access as big guys. They've never even attempted that.
Well, we've been talking a lot on this program recently about the National Broadband Plan, which was just introduced. How does this decision, in your view, affect that plan?
Well, I think it makes some parts of one of the things that the broadband plan has proposed, or at least just put up for discussion, is regulating the internet under Title II of the Federal Communications Act. I would say that this ruling makes that a moot point. I don't think there would be much support for that. The broadband policy that the FCC has proposed also wants to convert the Universal Service Fund from a hardline telephone service to a fund to compete, or at least to subsidize the private sector in deployment of broadband throughout America. I'm not opposed to broadband being deployed throughout America, but I don't see, if the private sector is doing it with its own funds, why we need to subsidize, or in some cases supplant public funds with private funds. So I think this ruling makes certain parts of their broadband proposal more difficult to enact.
Now, just to go back to the Title II, that would essentially, if they move broadband under Title II, it was essentially allow the FCC to regulate broadband as it does landlines right now, correct?
Correct.
John Kerry, Senator Kerry, was quoted as saying that Congress needs to act. I know that Congress did not intend for cable and telephone broadband internet service providers to fall outside the authority of the FCC to protect consumers. Essentially, he's saying that he thinks it should be moved to Title II, correct?
Well, that'd be one interpretation of her remarks. What I think your listeners need to understand is that Senator Kerry and Congressman Markey want an internet that the federal government, through the auspices of the Federal Communications Commission, has more control over. People like myself want an internet that is as free as possible of government interference. There may be general guidelines that the FCC sets for access, but in the specific case, we let the private sector fund the internet. We let the private sector, through free market interaction, determine the contracts by which the big users like Google and interact with Verizon or AT&T or Comcast. So we have it as government free as possible. Senator Kerry and Congressman Markey, although they call it net neutrality, that's kind of a wolf in sheep's clothing. They want an internet that the FCC sets terms and conditions on, has regulatory authority. That's what would happen if you put the internet and broadband under Title II of the Federal Communications Act.
They're talking about how this is going to become a big lobbying effort, and millions of dollars could be expended by companies and by interest groups who are involved in the net neutrality.
Well,
net
people
management.
that want to regulate the internet are going to try to overturn the court ruling legislatively, and I don't dispute that an act of Congress can trump a court ruling. I agree, but I don't think Congress needs to act. I think the court ruled properly. I think the internet has been a huge success. I think our general broadband policy that we put in place in the 1996 Telecommunications Act has been a big success. I don't want an activist FCC that's stepping in and dictating investment decisions and also setting terms and conditions for for pricing and access to the Internet. Mr. Markey and Senator Kerry appear to want that. I don't. And I don't think the American people do, and I don't think the majority of the users of the Internet do if you explain the issue to them. What confuses the issue is the term that is used, net neutrality, is something that if you ask people if you're for net neutrality, everybody would answer yes. But as it's implemented, net neutrality by Mr. Markey and Senator Kerry is not it's not neutral. It's just the opposite. It's a government regulation of the Internet.
Joe Barton is the ranking member of the Energy and Commerce Committee in the House of Representatives. Congressman, thank you for joining us on the Communicators.
It's my pleasure.
Well, one of the consumer groups that is very active in the debate on net neutrality is called Free Press. We also talked with Marvin Amori, who is the general counsel for that group, and in fact, he argued on behalf of the group in front of the three-judge panel.
Mr. Amori, when you were arguing for free press in front of the three-judge panel, what was your strategy?
Well, by the time I argued, the FCC had already argued, and it was pretty clear by that point that we were going to lose. And so the question was, how broad or how narrow would the ruling be? And so the strategy was just to encourage the judges to have very clear guidance to the public and the FCC, which is exactly what the court did. And the court was very clear in the ruling that the FCC would probably have to scrap its current regulatory framework in order to protect consumers on the Internet.
When you said you knew you were going to lose, could you give some brief indications of how you got that vibe?
Well, at that point, the Comcast and their intervener, the people on their side, had argued and gotten a few softballs. And when the FCC had argued, the D.C. Circuit was incredibly aggressive, didn't seem to buy any of the arguments. The D.C. Circuit, when I knew we were going to be in the D.C. Circuit, I had a pretty good idea we were going to lose. It's a very deregulatory, ideological court. And the last question that was asked of the FCC was, if you're going to lose, how do you want us to rule against you? Something narrow or on jurisdiction? And so when the court asks you, how do you want to lose, that's a pretty bad sign.
When you wrote about this on your blog, one of the sentences you used were, we were given the guidance we wanted, but not the answer we didn't. Could you expand on that?
Well, we wanted to make sure that the court made it very clear what the FCC would have to do to protect consumers. Right? The FCC believes they have a mission to keep the Internet open and free to all Americans, to ensure innovation and democratic speech is still available on the Internet, and that carriers can't just block speech and block new innovative technologies. And so the FCC really needs guidance. What should they do? And we were hoping that the FCC could continue on their current regulatory framework, which is a flawed framework. But as it turns out, they can't. They have to go back to the drawing board and actually adopt what I think would be the more accurate and correct statutory framework to regulate broadband.
And is that the Title II that we hear about?
That's Title II. So the analogy I try to use is, if you remember, people were talking about the financial collapse and deregulation. And people talk about CDOs, these shady instruments that are kind of like insurance, but not regulated like insurance. I mean, what the FCC did in the Bush administration was something similar. They classified a network technology, which is clearly a network, as though access to the Internet, as though it were Twitter or some unregulated technology. So what they have to do is essentially call insurance, call a network Title II, not Title I. Right? Internet access is not Twitter; it's more like the phone network.
So if say, per se, the FCC wanted to adopt Title II, is it as simple as the commissioners meet, they just debate about this, and there's a vote?
It's that simple. You just need 3 votes from the commission. And, I mean, in fact, it's clearly, in my opinion, the obvious way of reading the statute. Justice Scalia, in a dissent with 3 other Supreme Court justices, thought it was the obvious way of reading the statute. And several years ago, when Commissioner Copps, who's a Democratic commissioner and a hero on net neutrality, dissented from the original order changing the statutory framework from Title I to Title II, he described this as a gigantic leap away from Congress's statutory framework into the FCC's no man's land. So I think it'll be an easy thing to change if the FCC can withstand the political pressure. It's not a legal question so much as a political question, and the carriers are very, very powerful. They give a lot of money to congressmen. They have a lot of influence in Washington, and it's really a question of will the public stand up and stand with the FCC in doing the right thing, or will the carriers have their way?
So specifically on the political front, do you think Chairman Janikowski has the will to do that?
I think Chairman Janikowski is a great, smart guy. I do think that any person who wants to act, any regulator who wants to act in favor of the public really needs the public standing loud and strong with him. I mean, it takes a lot of will to stand up to these powerful carriers, a lot of DC influence. And if the public stands with him and says, you know, we stand for an open internet. We believe that we should have access to any site on the internet. The internet in the U.S. should be freer than it is in China, even if it's delivered to us by private companies. Right? If the public stands with Julius Janikowski, I think that makes it a lot easier for him and the other two commissioners whose votes will be needed to do the right thing.
As far as responses to this, one of those responding was the former FCC chairman, Michael Powell, and he said specifically when he was talking about Title II, he said that if the FCC wanted to establish itself as the internet overseer, it would continue to have serious jurisdictional problems. How would you respond to that?
Michael Powell is wrong, and he's the one who got us into this mess. It was his decision when he was chairman to start deregulating and to reclassify things that have really harmed our internet infrastructure. And he's absolutely wrong. If the FCC reclassifies, what they do is they then have the authority to regulate internet access, which is the access provided by cable and phone companies, and they will never have the authority to regulate things on the internet, like you sharing photos on Facebook or Twitter. What Michael Powell did was confuse that distinction.
You talked about the Title II aspect, but when you posted on your blog, you were somewhat hopeful on some areas. Could I ask what you think about what this decision and what it means for elements of the National Broadband Plan?
Well, that's where I'm slightly less hopeful, actually. So this decision goes far beyond network neutrality. So network neutrality is the concept that people should be able to go wherever they want on the internet, create any technology, and not need permission from their phone or cable company. And there's a huge right-left coalition called SaveTheInternet.com organizing around net neutrality. But beyond that question of net neutrality, this jurisdictional ruling by the D.C. Circuit implicates a whole range of things that the FCC could do in their national broadband plan. And the General Counsel of the FCC posted a blog about it. It includes things like ensuring access to all Americans in rural areas and in underserved areas, making sure that we have cybersecurity, consumer protection, privacy. There's a whole range of things that are implicated by this court decision that really, I think, necessitate the FCC to go back to the drawing board, reverse the terrible policies adopted by Michael Powell and that commission, and put the FCC on firm regulatory footing for the major communications infrastructure of our time, the internet.
Chairman Waxman had said that he would work with other Democrats on the House Energy and Commerce Commission on possibly finding ways to give the commission more legal authority. What could they do from a congressional standpoint?
Well, I mean, Congress could pass a statute that would clarify this issue. I'm a little skeptical that Congress can move quickly enough. And in the meantime, the FCC should just act to get back within the regulatory statutory framework that exists. And over the next 2 years, Congress can debate the issue. And there'll be a full-out press by the phone and cable companies who have tons of influence in Congress to try to hijack the process. In the meantime, the FCC has to do things to make sure that our broadband infrastructure, which has fallen far behind from the world leaders in terms of speeds, prices, openness, that our country doesn't fall behind in this critical infrastructure and hurt our economy in the next few years.
Our guest serves as a law professor for his job, also the general counsel for Free Press. You can find more about their decision, their response to it, freepress.net. Marvin Amori, thanks for your time this morning.
Thank you so much.
Also on the Communicators this week, Howard Simons, a lawyer who argued on behalf of the National Cable and Telecommunications Association.
Mr. Simons, does this week's decision about the Comcast case and or at least the discussion about the authority that the Federal Communications Commission has over broadband providers?
Does it end it?
Yeah.
No, I think it may take it to a different chapter, but I don't think it ends it at all. There's been a lot of talk in the last couple of days since the decision came down that this is the end of the FCC's authority over broadband. Lots of apocalyptic statements from the proponents of net neutrality, some within the commission and others. but I think what the decision really says is that the FCC has to be more careful, more rigorous in finding sources of authority to regulate in this area.
You said that could open the next chapter. What's that chapter mean? Is that what we've heard about this week, Title I versus Title II? Is that the next chapter?
That chapter was opened already. The net neutrality proponents earlier this year, and in fact over the past couple of years, have argued that Title II, which is the part of the Communications Act that regulates the telephone utilities, is the proper source of authority for broadband regulation. That's not a new idea. That's an idea that's been kicking around for years. I think the net neutrality proponents have seized on the court decision this week to give more momentum to that, and that certainly will be part of the debate. But I think an equal part of the debate will be the ability of the FCC under Title I, which is the part of the Communications Act that more lightly regulates information services, whether Title I remains available to the FCC as a source of authority. I think there is a serious debate to be had over the extent to which Title I does remain available.
And is there a way to expand Title I to give the FCC more legal authority?
I wouldn't say expand Title I. I think what the D.C. Circuit said this week is something it has said in a number of other cases over the past couple of years. And that's that Title I is not a blank check for the FCC. It is a source of flexible authority. It has been used that way by the FCC for over 40 years now. And the D.C. Circuit, the court, didn't take that authority away. What they said to the commission was, if you want to use Title I, you've got to link the exercise of authority in that title to some affirmative grant of authority that Congress has given you in some other part of the Communications Act. And that sounds like legal mumbo jumbo, I guess. But what it does is it's a framework designed to keep the commission focused on how it uses Title I authority so that it is linked to their statutory responsibilities and not totally open-ended.
Before this decision, the chairman had announced the idea of formalizing 4 principles, as it were, when it dealt with the internet and adding 2 more. Mm-hmm. What does the decision, do you think, mean for that process of formalization? Does it stop it? Does it change it?
I don't think it necessarily has to stop, but I think what the decision does is put the commission to the test of articulating bases in the Communications Act for those principles. And in fact, the FCC itself recognized that test even prior to the court decision this week in the announcement of the proposed rules last fall. The FCC itself asked the question, which provisions of the Communications Act can we link our proposed net neutrality rules to in order to exercise our so-called Title I authority? So this is not a new issue even for the FCC. They recognized that this was something they would have to lay out in order to justify their rules under Title I.
Since so much went back to the original act, do you think that because of this decision and others, a reworking of the act by some would be an effort that would be made?
I think certainly there are those who have called for that in the communications industry. There are folks on the Hill who've suggested maybe it's time to look again at the Communications Act and update it. I think those efforts are always appropriate to consider. I think the Communications Act, even as it stands today, is a pretty robust document that potentially provides authority for the FCC to regulate in the broadband area if it proceeds carefully and if it can justify it. And I think the ball's back in the FCC's court to explain how they can do that. I think the D.C. Circuit decision is not even a wake-up call. It's more like the snooze button going off, saying if you want to use Title I authority, you've got to be rigorous. You've got to be analytically precise. The problem with the order that was overturned was it was none of those things.
On the aspect of possibly reclassifying as Title II, if there are legal questions that have to be addressed if that reclassification takes place, what are some of those questions?
I the fundamental question is what has changed since 2002 when the FCC first classified broadband service as an information service. I think there's a real factual hurdle that the Commission would find difficult to get over, because the characteristics of broadband service the Commission relied on in 2002 really haven't changed that much. Internet access is really a service that connects people to the internet. The underlying transport, the broadband pipe, if you will, is not separately sold to people. You don't buy a pipe plus internet access. That when the Supreme Court upheld the FCC's determination that broadband service was an information service, they themselves, the court itself, relied on that factual determination. There was quite a debate back and forth between the majority opinion and the dissent over whether there were two separate offerings or one separate offering. Was it a pizza with toppings? Yes, that's one offering. Or was it a dog and a leash, two separate offerings? That was the debate. The FCC said it was a pizza with toppings, and the Supreme Court agreed, and it really hasn't changed very much since then. So they're going to have to say what's different, what characteristics are different, and I think they're going to have a very hard time.
Some on the Commission have advocated for this reclassification. Do you think that the Commission has a will to do it?
I think it's too early to say. Certainly there have been people at the Commission who have long advocated this approach. I think the Commission, Republican and Democrat, dating back to the 90s, dating back to the Clinton administration, has resisted those calls, and correctly so, because of the complexity of regulation that reclassification would bring down on broadband. Title II regulation is not just telephone regulation. Title II regulation is railroad regulation, and in fact the Communications Act's telephone section was lifted from the Interstate Commerce Act from the 1880s, designed to regulate railroads, and that in turn was lifted from centuries of English common law that go back to cartage laws, carting hay around in England in the 1700s. That's not a regulatory framework that's appropriate for broadband in the 21st century.
Were you surprised by the decision, especially the unanimous decision from all three judges?
In all honesty, I was not surprised by the decision. I think the judges were awfully clear in their questions. It's a truism when you argue cases that you can't really conclude very much from oral argument, but in this case I think the oral argument really did foreshadow the decision.
Finally, a perspective from Markham Erickson. He's the executive director of the Open Internet Coalition. When you put out the statement on the Comcast decision, you called this a dangerous situation. Why use those words?
Well, you know, it's a dangerous situation in that currently there's, under the existing legal theories that the Commission has cobbled together, there is no recourse if an internet access provider blocks lawful content or refuses to let you go to a website that you want to go to or interferes with your communications over the internet. So, you know, that is a situation that I think most policymakers think is not tenable, certainly not what Congress intended in the '96 Telecommunications Act.
And then later on in the statement, you said that the decision invited the Commission to proceed against broadband providers under Title II. Yeah. How did you get to that?
Right. So in many ways, I think this is a very good decision for us and for the internet community and for consumers. And that it's
which you represent.
Which I represent. It's a clear decision. It's a clear repudiation of the legal foundation beginning in 2002 that the FCC put together of relying on what they call ancillary authority to govern and police the activities of internet access providers for doing the wrong kind of things. In 2002, the FCC said that cable modem services, and then later they said that telecommunications services that provided internet access were not telecommunications services, they were information services. Many thought that was the wrong decision at the time, and a lot of the assumptions, the policy assumptions that led to that decision haven't panned out to be the case. So for instance, in 2002, they thought, many policymakers, that by 2010, consumers have many more choices for internet access. There would be much more intermodal competition. You would have broadband over power lines and satellite and wireless. And what we've come to learn is that for the foreseeable future, most consumers will have one or maybe two choices for high-speed internet access. And so these companies are really the gatekeepers and control the on-ramps to the internet, which is a public forum. So because of their gatekeeper role and because of the service they provide, they really ought to be considered essential communications platforms, just like the telephone. And if you consider them to be essential communications platforms, which I think the internet has replaced telephony as an essential communications platform, then they ought to be treated as telecommunications providers. Once the FCC does that, which would be to reverse the 2002 decision, then they're on solid legal foundation, and then they can proceed forward against the very acts that Comcast engaged in, which caused this complaint to happen in the first place.
And is that the Title II reclassification you're talking about?
That's the Title II reclassification issue. It's not that complicated a procedure. Essentially, the procedure happened in 2002 to declassify, and the Commission can revisit that decision and reclassify into these services into Title II. It does not mean, however, that they're subject to the full bore of Title II regulations. We wouldn't be talking about re-regulating these providers. We'd be talking about creating a solid legal foundation so that the sort of light touch proposed rules that people are talking about to protect consumers from some of the most egregious behavior are in place. And that, I think, benefits all stakeholders because you have certainty at that point for innovators in Silicon Valley that they can come up with products that won't be blocked or interfered with. The telecom companies and cable companies have certainty because they know what the legal foundation is and what the rules are. And consumers have certainty that their internet experiences aren't going to be messed with. So I think that benefits all stakeholders in this space.
A simple decision to make at the Commission's end, but what about the legal challenges if that would ensue? Do you think they would ensue? And then what do you think of the difficulty as far as a legal fight this would produce if that reclassification took place?
The Commission never does anything that doesn't result in a legal challenge. So it keeps lawyers busy. Absolutely, there'll be a lawsuit. But the reason this case was so helpful, it was a test case. The test that the FCC was proposing to build its legal foundation failed. So if they move this forward under the Title II regime, they'll be challenged. But as long as in Title II they make a decision that's based on the facts and based on well-reasoned technical analyses, it's going to be very hard for a appellate court to overturn that. Those are where agencies are in their strongest position when a commission's making an expert determination. It's very hard for a circuit court to second guess those kind of decisions. So I think they have a much better chance actually in that situation of surviving a legal challenge. And once that happens, then I think we're moving forward with some certainty on how policymakers can treat the internet access providers.
Even during this process, you had companies such as AT&T, Comcast saying they were still committed to the idea of an open internet, even though this legal proceeding was going on.
Yes.
Why not at least leave it at that with the idea that perhaps self-policing might be a way to go?
It doesn't work. So our view is trust but verify. There has to be some enforcement mechanism at the end of the day to keep these companies honest because while those entities since 2002 have been saying that they're for openness, we've seen examples like the Comcast situation where actually they've engaged in activity that's been the very opposite of the things that they publicly stated that they were for. And so they've blocked lawful content. And when they block lawful content, unless there's some sort of complaint process and recourse, it's very hard just to shame the companies into changing their behavior. There has to be some sort of heavier stick than that.
Some have said during this process that this is a great victory for content companies like Google because they use a lot of bandwidth, they bring it down, and virtually they see no, they see no recourse for their actions, so to speak. What argument would you make as far as you representing these type of companies about the type of bandwidth that goes off, which was initially the content moving over the lines was what brought this to the forefront in the first place?
Right. So that's where I think everyone benefits by some clear rules. The only way we get clear rules is by having a solid legal foundation, which is why I think the FCC has to move to reclassify. Once that happens, the network operators will be able to promote rules, and we'll support them on this, that allows them to engage in network management activities to deal with issues about increasing bandwidth and how you deal with the traffic that may be overwhelming a network. So those are issues that that the ISPs ought to have a great deal of flexibility to engage in. But right now, they're not really sure what the rules are in that space. So I think having some clear set of rules helps everybody in that space know what to expect and where the lines will be drawn in terms of permissible activity and things that cross the line into impermissible activity. In the Comcast situation, Comcast at least initially argued that they were blocking lawful content because of bandwidth issues. But then the facts that the FCC developed in their investigation showed it was the opposite. Comcast was blocking the application even when there was no congestion on the network. So there has to be some sort of oversight that can verify what the network operators are saying to ensure that that the activities they're engaging in, especially when they're blocking lawful content, is actually done in a way that is sound public policy, promotes sound public policy.
Mark Amerikson with the Open Internet Coalition. He's their executive director, openinternetcoalition.org. That's the website. Thank you.
Thank you.
Thanks for joining us for the Communicators this week. If you would like to read the 3-judge panel's decision on net neutrality, net management, you can go to cspan.org/communicators, where you can watch all of our previous programs as well. Thanks for being with us.
Fridays